Did you know that without a valid will in Ecuador, your assets could be distributed under local laws and not under your wishes? All assets located within the country are governed exclusively by Ecuadorian laws, regardless of the owner's nationality. According to our civil code, if a person owns property in Ecuador, the inheritance and succession of those assets are regulated by Ecuadorian law, not by the law of the country of origin. In this video, we will walk you through everything you need to know regarding how to have a valid will in Ecuador, step by step. From the essential legal requirements to practical tips that will ensure your wishes are fully respected. Stay with us and learn how to protect your legacy safely and in full compliance with the law. Let's go straight forward to the key points. Right now we're going to discuss the legal requirements or the important legal knowledge to have when it comes to preparing a will. The first thing to know is that your residency status or your immigration status does not affect your ability to grant a will here in Ecuador. In the same sense, the immigration status of a person does not affect their ability to be a beneficiary on your will. So both the grantor and the beneficiaries of a will could be non-Ecuadorian residents. Also, now let's discuss about the language on the will. The language on the will is really important in two different aspects. The first aspect is the language in which the will itself could be prepared. By law, the official document to be executed in Ecuador needs to be in Spanish. Okay, so if you are not a Spanish-speaking person, we need to have both the Spanish legal version, which is the one that will be executed, and then we need to have the English version that shows that you were fully aware of what you were disposing on your will for the legal validity of it. This means that even though the will must be done in Spanish at the notary, we also need to file an English copy along with it. In this same topic, as a special requirement for you being an expat, in Ecuador you must have a closed will. This is only because of two main reasons. One, because you're not of Ecuadorian nationality, and two, and the most important one, because you do not speak the language. Matter of fact, if you were not an Ecuadorian resident, but you did speak fluent Spanish, we could have an open will. If that is not your case and you don't speak Spanish, then you must have a closed will. The third important aspect is the notarization. The will in Ecuador must be notarized for it to be legal, okay? So we need to complete a process at the notary office. First, you go to your attorney, you present your assets, you discuss your beneficiaries and the specifics of your case, which we will also discuss later. And once the draft of the document is prepared in both Spanish and English, as I just explained, then we need to take it to the notary. Basically, the role of the notary is to give faith of the validity of the legal requirements that have to concur in a will, such as making sure that the grantor of the will is mentally capable and conscious, and that her or she is not being forced to grant the will. Also, they need to make sure that all the witnesses are in full capability to be able to witness a will, okay? The witnesses need to have certain requirements that must be observed, and we will discuss that later. One aspect that it's also important to observe on the notarization is that you, as a non-Spanish speaking person, even though the will be both Spanish and English, need to have a translator during the whole notary process. This collaboration or your appearance with the translator must be filed within the notary act that goes along with your will. Now let's dig into the witnesses. If you are, which is the most common case, an expat that does not speak Spanish, and therefore, as I said before, you need to have a closed will, you need to have 5 witnesses to be with you at the notary process. The witnesses need to follow certain requirements. Number 1, they need to be older than 18. Number 2, they need to be fully mentally capable. Number 3, they need to be residents in the city that you're granting the deed. Number four, excuse me, not the deed, the will. Number four, they need to be of Ecuadorian nationality, and of course they need to speak Spanish. Regarding what happens at the notary, it's important to know that because you have a closed will, again, the most common case is that you are an expat that does not speak Spanish, the notary does not really have access to the will. So your attorney will provide you with an English copy and a Spanish copy of your will, as I have already explained, for assuring the validity of the content of the will. And it must be provided, or those two copies must be provided signed and inside a closed envelope. And that's why we call it closed will. Honestly, there is no difference when it comes to the legality, validity, or execution process of a closed will to an open will. The main difference is the number of witnesses, 5 versus 3, the fact that the content of the will is not public, and some little difference at the moment of opening the will once you pass away that honestly are very technical legal aspects that are done at the notary. It doesn't really have a practical implication on the execution of the will. The other really important thing to be aware of is that in Ecuador, such things as joint wills are not recognized. This means that you must have an individual will. Each person needs to have its own personal will. Even if a couple is married, legally married, and even if their marriage is registered in Ecuador, cannot produce a joint will. This is not recognized under our law. And it's a really important thing to understand because it's the main difference from the US law. Now let's dig into the content of the will. What we have already studied, the formal requirements, the language, the notarization, the witnesses, whether it's closed or open, whether it's individual or joint. But what can you actually say or dispose in this will? Regardless of you being an expat, as I said before, all assets placed in Ecuador are ruled by Ecuadorian law. So Ecuadorian law must be observed. So under those considerations, Ecuadorian law does not allow you to have 100% of your assets as free disposition. We have certain limitations of to whom you can give and in which proportion you are allowed to give in your will, okay? If the grantor of the will, in this case you, have alive parents or children, 50% of the assets that you have and that are included on the will must be distributed to them in equal proportions. 25% of the assets must be distributed to descendants. This could be children, grandchildren, grand-grandchildren, and beyond. And it can be given either to one or many in the proportion wished. There is no limitation here, in difference to the 50% that we just discussed priorly, which has to be distributed equally among the children. And only 25% of your assets are of free disposition, so you can give it to anybody you want in the proportions that you want. As a summary, if we have a cake, 50% of the cake, so half of it, goes to the parents and children if you have it. 25% must go to a descendant or many descendants. Here, this 50% is in equal percentage. This 25% it's in whatever percentage you like. And then only the last 25% is of free disposition. Also, something really important to take into account, and something that most of my colleagues forget, is that under Ecuadorian law, if a couple is legally married, doesn't matter if they were married in a different country, as long as they are married and Ecuador is aware of this, we have something called conjugal society or sociedad conyugal, under which all assets are divided between the spouses 50-50. Regardless if the assets are only under one of the names of the spouses, that all the assets are always divided 50-50. So for example, a very common example is if you have a bank account. A bank account, it's usually under one person's name, But even if that is the case, the money contained in that bank account, it's 50 yours and 50 your spouse's. The same thing if you have a house, a car, artwork, or any other assets under only one of the name of the spouses. By law, everything is 50-50. This means that each spouse then can only divide 50% of the assets, of the total assets that you have as a marriage, on his or her individual will. It's also very important to know that, for example, my wife has this bank account on her name, right? And myself, I'm going to have my own will. In my will, I will have to include her bank account, and I'll have to indicate what I want to be done with my 50% on her bank account. So in my will, I have to include the assets only my exclusive name, the assets under the exclusive name of my spouse, and the assets that we have on both of our names, and I can only dispossess 50% of all those three. This is for married couples. For those single, basically your patrimony, it's all yours, but you still have to follow the rules of the children and descendants that I have already explained if you do have them. Most expats do not like this aspect of Ecuadorian succession law. You sometimes don't want to be tied to give anything to your children because you want everything to go to the living spouse, for example, or there is these children that you really don't like, or maybe you just like them all, but you want all of your assets to go to charity. In solution, beyond the law, there are scenarios where we can change the restrictions of the law, which we can modify through different methods or different legal strategies. Sometimes by including a special clause, sometimes by doing some previous documents, but this will depend on your specific case. What aspects can affect your case? For example, whether you have or do not have children living in Ecuador that the Ecuadorian government is aware of, so we can declare or not declare these children in your will. That is a common example. But those more practical aspects or solutions beyond the law that will allow us to not observe what the law actually strictly establishes depends on practical aspects that must be evaluated per each individual case, further on a consultation. This will allow us to determine the best strategy, clause, or document that we need to prepare, assuring that the will does not get nullified. Because, of course, if the law exists, it's there for a reason and it must be observed. If we want to have the possibility of overlooking or not observing this law under certain practical considerations, we must do it very, very carefully in a very detailed manner so that we can assure the legality and validity of the will. Now let's discuss about what are the most common mistakes that expats and sometimes legal advisors will explain or advise to expats. The first most common mistake is assuming that a foreign will is valid in Ecuador. It's important to understand that even though under certain procedures such as apostilles, you can have a foreign document being executed in Ecuador, if a will does not observe the laws of Ecuador that we have already discussed, then it's not valid. For this reason, I always recommend that you have your Ecuadorian will for your Ecuadorian assets and you have a will for all the other country where you have other assets. The second very, very common mistake is thinking that you need to change the will every time your patrimony changes, even if it is a slight change, and on the other end of things, thinking that you don't need to adjust your will when major changes thing. Those are two common mistakes. Thinking that the will needs to be updated every time that you acquire new property, it's not true. With the proper legal clauses on the will, we could cover your assets that are currently part of your patrimony and also your future assets. There is actually no need to update the will every time your assets change slightly if we do have the proper clause on the will. Why do I insist that much saying if we have the proper clause, if we have the proper clause? Because What most legal advisors usually do is just list on the will the assets that you currently have and then say how they must be distributed. If that is the case, your will absolutely need to be adjusted or actually repeated from scratch every time your patrimony changes. But again, with the right classes, this could change, saving you money and time to having to create a will every time. As a matter of fact, by having this class that I'm talking to you, which we can further discuss in a consultation, you can have full protection of your asset, except one specific or two specific cases where I do recommend to adjust the will. Acquiring real estate property, okay? Or acquiring a new CD on a bank that you didn't have before. For example, when we did your will, you had a CD in JEP, the CDs change, they expire, you renew them, the interest rate changes. With the proper clause, that would be covered. But maybe later you want to have a CD also on Produbanco. That's a different bank. Therefore, I do recommend to adjust the will. As an example of this that I'm saying, or this recommendation that I'm making with you, recently, we had a client who had a will done listing specific assets and not including this clause that I'm talking about to cover other assets. He didn't update the will and acquire real estate property. As a result, the children faced a 2-year legal battle to be able to fix this problem and have access to the inheritance. Luckily, they reached out to us and we were able to solve this in a timely manner, but they definitely went through a legal nightmare before that could have been avoided just by the simple fact of adjusting the will, or in the case that it was not real estate but artwork or jewelry, by having the clause that I very much advise you to discuss in a private consultation with us. I do want to emphasize, if you get a will done that does not have a clause for protecting other assets and basically just lists the assets that you currently have, then yes, you do need to adjust the will every time you have a change on your assets, regardless of how slight this change is. That's the reason why here at Expat Law Group, we never advise to do this type of will, because it will basically force you to keep wasting, basically to me it's waste, money every time you have a little change on your assets. Now let's go to the other end of things, which is major changes, okay? So right now we have already covered what happens when I have a slight change in my patrimony and I do have the right clause on my will. Then I do not need to change my will or adjust my will. But what happens if a major change does occur? For example, getting divorced or married. In that case, it's common and almost the general rule that yes, you do need to adjust your will, even if you had the clause that I'm talking about or that I have mentioned, because this is a change on your marital status and therefore, here it comes, conjugal society. Either the dissolution of conjugal society and a different distribution or major change on how the assets were assigned between you and your ex-spouse, or if you get married, now you would have conjugal society with your new spouse, and this needs to be observed in the will. A very common second mistake is overlooking the legal limitations of how the assets could be divided. This is the topic that we have already discussed. Remember the cake, 50% to parents and children if you have them, 25% for descendants, and 25% for free disposition. It's important to understand that if you do not observe those rules, your will therefore will be nulled, and therefore it's no valid. It's almost like not having a will done at all. Another common mistake is thinking that you can have joint wills. I already made it really clear. That's not possible. Each person needs to have an individual will. And if you are married, it's important to understand that you can only dispose 50% of the assets that you have in the marriage. Now let's discuss some common questions that expats have regarding wills. Can I include assets outside of Ecuador in my will? The short answer is yes, but the Ecuadorian government can only have governing or jurisdiction over local assets. Therefore, the provisions for the assets that are outside of Ecuador must observe the laws of that country. For this reason, I recommend having a will in Ecuador for Ecuadorian assets and have separate wills on each country where you have assets for those places there. What happens if I die without a will in Ecuador? Here is when our law jumps in the big way. Basically, the assets will be distributed under Ecuadorian intestacy law. And under this law, basically we have an order that progressively gets applied. If you died without a will, the government needs to look out for your children. If you do not have children, it looks out for the spouse and the parents in the same level. If you don't have your parents alive, then everything for the spouse. If there is no spouse, it goes down to the siblings. No siblings, it goes down to nephews and nieces. And if that's not the case and you don't have nephews and nieces either, or none of these people come to Ecuador and show this link with you, lastly, but also jointly with cousins, if they do show up, the Ecuadorian government. For this reason, it's important that if you are living solo in Ecuador, your family lives somewhere else, or you don't have a good relationship with them, or they are not interested to come down to Ecuador when you pass away, it's really, really important that you have a will, or the likelihood of the Ecuadorian government inheriting all of your assets becomes real high. How much does it cost to create a will in Ecuador? Honestly, the fees vary so much, especially depending on your age, on the witnesses available at the time, of the number of assets and valuation of each asset, the number of beneficiaries that you want on your will, that providing an approximate fee, it's really, really difficult. But it's a very important little piece of information for people that are older than 65 years old. The notary fee is around $30. It's actually strictly $15, but we have to add up expenses in the copies of the witnesses, of the translator, of yourself, and the notary will charge you a fee for each extra page. Therefore, it usually adds up around $30. While for someone that it's not older than 65 years old, the notary fee goes around $600. So that is a very important variation of fees that you do want to have in mind regarding notary fees when you consult with your attorney. Once again, it's really difficult to set a specific set of prices for a will regarding the legal fees because it will depend mostly on the number of beneficiaries, the number of assets, and the price of your assets. Let's do a little recap. Number 1, you must have individual wills in Ecuador. Number 2, it's important that you have an Ecuadorian will for your assets in Ecuador. And the process for producing a will be meeting with the attorney, preparing the draft in both Spanish and English, going to the notary, proceed with the notarization of the 2 copies with a translation or a translator next to you, have 5 witnesses. Remember that expats that do not speak Spanish need to go for a closed will. It's also important to remember that if you died without a will here in Ecuador, there is no way for us to avoid the distribution that I have already explained under intestacy law, being very likely to have the Ecuadorian government to become owner of your assets. Therefore, it's important that you do prepare your will. Another important consideration is that if your will is not done properly regarding this process that I just quickly summarized for you again, but also if the content of the will is not correct, meaning that the assets are not distributed, taken into account the conjugal society, the limitations of the distribution of assets when you have parents or children, or it only lists the present assets, but it does not have the proper clauses for future assets, then your will could get either partially or fully annulled. For this reason, it's really important that you go to a proper legal advisor that can navigate with you the whole process of preparing a legal will in Ecuador from both the external requirements and the content requirements. Protect your legacy. Contact Expat Law Group to draft your will today. I invite you to contact us to have a free 15-minute consultation with me in which I could answer the specific questions for your case, and later we could start getting ready to prepare your will.